Hello, and welcome back to the OCO Roundtable podcast. From Orara & Company Advocates, my name is Melanie Mwenda, and I am your host today. Joining me again as part of our data protection experts is John Mbaluto. He's the Deputy Managing Partner at the firm in the Dispute Resolution Practice Group, and he has a wealth of knowledge and experience in data protection laws and regulations. John has helped many companies navigate the complexities under the Data Protection Act and other data privacy laws, ensuring they remain compliant while protecting user data. We are also joined by Maurice, who is a senior associate in the firm's corporate and commercial practice group and has advised both local and international clients on corporate restructuring, corporate advisory, mergers and acquisitions, privatizations, and infrastructure projects, in addition to his vast experience in data protection. Welcome, John and Maurice.
Thank you, Melanie. Excited to be here.
Thanks, Melanie. Like Maurice, I'm also excited to be here.
This is the third episode in our data protection series. In previous episodes, we looked into what the first 100 days of a data protection officer should look like. We also delved into the key considerations that organizations should consider and implement in order to foster a privacy-centric culture. In today's episode, we continue with this conversation by exploring the critical and often controversial topics of data localization and data transfers. As our digital footprint expands globally, the way our data is stored, transferred, and protected has become a focal point for governments, businesses, and individuals alike. We'll discuss the impact of data localization laws and how they affect international businesses and the free flow of information. We'll also shed light on the concept of appropriate safeguards, why they are necessary in undertaking data transfers, and practical steps in protecting data upon transfer in this evolving landscape. So Maurice, you can start by letting our listeners know what data localization actually is.
Certainly, Melanie. Well, to begin with, data localization entails storing data within the borders of a specific country or region as mandated by local laws or regulations. It refers to the requirement that data must be stored within a country's borders and in line with other requirements of restricted transfer of personal data. Practically, what this means is that personal data obtained within a particular jurisdiction must be stored either physically or on servers located physically within that jurisdiction. In the event that such personal data is required to be transferred outside the jurisdiction, appropriate safeguards must be demonstrated alongside the consent from the data subjects. This is a contentious topic as it involves protecting individual rights to privacy, ensuring national security, and regulating cross-border commerce. This is because while the free and secure exchange of data across border is crucial for purposes such as commerce amongst other reasons, the implementation of such privacy legislation and regulation must be done in a manner that recognizes the need for seamless flow of data while at the same time maintaining trust and compliance with data protection standards. It is a concept that has gained attention with the rise in global data flows and the associated potential for misuse of data. In Kenya, the Data Protection Act only allows data controller or processor to transfer personal data outside Kenya solely upon receiving the consent of the data subjects and providing evidence to the Office of the Data Commissioner that the transfer will be conducted securely or to a destination with data protection laws that are at least robust as those in Kenya or even stronger.
That's very interesting, Maurice. Now, I'm just wondering, so given the importance that is placed on restricting transfer of data outside the country, why would one still require transferring data outside of its borders?
Well, there are a number of reasons why cross-border data transfers may be necessary. To begin with, cross-border data transfers are necessary for globalization and business operations. In an interconnected world, businesses often operate across multiple regions and jurisdictions. Such data transfers are therefore necessary to facilitate communication, collaboration, and the operations between different branches, subsidiaries, partners, and the stakeholders who are located in different locations. Secondly, cross-border transfers are useful for collaboration and innovation. Collaboration and innovation often require the sharing of data and information between individuals, teams, organizations, and research institutions that are located in different parts of the world. Data transfers therefore enables the collaboration on research projects, product development, joint ventures, and other initiatives that drives innovation and progress. Thirdly, it's also important for data analysis and insights. Data is a valuable asset that businesses use to gain insights, to make informed decisions and improve performance. Data transfer is therefore necessary to aggregate, analyze, and process data from multiple sources, including internal databases, external partners, customers, and suppliers to drive meaningful insights and actionable intelligence. Another reason why cross-border transfers are necessary is because of customer service and experience. Providing personalized and responsive customer service often involves accessing and transferring customer data across various systems, platforms, and channels. Data transfer enables businesses to deliver seamless and integrated customer experiences, improve satisfaction, and build long-term relationships with customers. Lastly, data transfers are also useful for disaster recovery and business continuity. Businesses need to replicate, backup, and restore data across geographically dispersed locations to mitigate the risk of data loss, system failures, natural disasters, cyber attacks, and other disruptions to operations.
Thank you for that introduction, Maurice. We indeed are a global village. Over to you, John. So what particular concerns arise when transferring personal data, either locally or outside Kenya?
Thanks for that question, Melanie. The transfer of personal data across borders raises significant concerns related to privacy, security, and overall compliance with data protection regulations. Some of the key concerns arising in the transfer of personal data are as follows. So number one is data security. One of the primary concerns is the security of personal data during transfer. Data breaches, unauthorized access, interception, and cyber attacks pose significant risks to the confidentiality, integrity, and availability of personal information. Ensuring robust encryption, authentication, access controls, and other security measures is therefore essential in order to protect personal data from unauthorized access or disclosure during transfer. The other concern is data privacy. Personal data transfer raises privacy concerns related to individuals' rights to control their personal information and protect their privacy. Unauthorized or uncontrolled transfer of personal data may violate individuals' privacy rights, leading to loss of trust, reputational damage, and legal consequences for organizations. Compliance with data protection laws such as the Kenyan Data Protection Act, the EU GDPR, and other applicable regulations is therefore crucial in order to safeguard individuals' privacy rights and ensuring lawful processing of personal data. The other issue is a key cornerstone known as consent. Obtaining valid consent from data subjects before transferring their personal data is essential to comply with the data protection regulations. Data subjects must be informed about the purposes for which data is transferred, who the recipients of their data are, and any potential risks involved in the transfer of data. Failure to obtain proper consent or processing personal data without lawful basis can lead to regulatory penalties, lawsuits, and even reputational damage for organizations. Another concern is data integrity. This entails maintaining the accuracy, completeness, and reliability of personal data during transfers, which is critical to ensuring its usability and trustworthiness. Any alteration, corruption, or loss of personal data during transfer can have adverse effects on individuals' rights, interests, and also well-being. Implementing data validation, verification, and error-checking mechanisms helps preserve data integrity and prevent data quality issues during the transfer process. Lastly, we have cross-border legal and regulatory compliance issues. Transferring personal data across borders involves navigating complex legal and regulatory requirements in different jurisdictions. Organizations must therefore ensure compliance with applicable data protection laws, regulations, and international data transfer mechanisms, such as adequacy decisions, standard contractual clauses, binding corporate rules, or other lawful mechanisms. It is therefore important to note that failure to comply with the legal and regulatory requirements can result in severe consequences, including fines, penalties, legal liabilities, and reputational harm.
Now, picking it up from where John has left off, we have all these privacy and security issues that he has shed light on. Do we then have a regulatory framework that safeguards the transfer of this personal data? Maurice, maybe you can shed more light on this.
Well, there's regulatory frameworks in place relating to data transfers, both locally and regionally. To begin with, let's look at the regional framework available across Africa. First up, we have the Africa Union Convention on Cybersecurity and Personal Data Protection, otherwise known as the Malabo Convention. The Malabo Convention aims to address issues related to cybercrime, data protection, and cybersecurity within African nations. Particularly, Section 3 relates to obligations and conditions governing the processing of personal data, and Article 14 specifically restricts the transfer of personal data to non-member states of the African Union, unless such states can demonstrate an adequate level of protection of the data. Secondly, you have the Supplementary Act on Personal Data Protection within ECOWAS, which is the Economic Community of West African States. ECOWAS has been actively working on issues related to data protection and cybersecurity within the region. The Supplementary Act on Personal Data Protection within ECOWAS was adopted during the 37th session of Heads of States and Governments on February 16, 2010. The Act seeks to establish a harmonized legal framework for personal data protection within the ECOWAS in order to address privacy concerns maybe arising from the increasing use of ICT and the Internet. In addition, it recognizes the importance of personal data protection in the same context. Likewise, Article 36 specifically restricts the transfer of personal data to non-member states of the African Union, unless such a state can demonstrate an adequate level of protection of the data. Next, let's have a look at the regulatory framework with regards to data transfers in Kenya. Data localization requirements are laid down under Section 48 of the Act and Regulation 25 of the Data Protection General Regulations. The term data localization is not defined under the Act, but it introduces certain restrictions with respect to cross-border data transfers. The Act prohibits cross-border data transfers unless a person can demonstrate the following. 1. Proof of appropriate safeguards with respect to security and protection of personal data. 2. One is required to demonstrate the appropriate safeguards in place, including jurisdictions with commensurate data protection laws. And lastly, one is required to demonstrate that such transfers are necessary for reasons including the performance of a contract involving data subjects, or the conclusion or performance of a contract concluded in the interest of the data subject, or a matter of public interest, or for the establishment, exercise, or defense of a legal claim, or for protecting the vital interests of data subjects, or for any other persons where the data subject is physically or legally incapable of giving consent, or for the purposes of compelling legitimate interests that do not override the interests, rights, and freedoms of the data subjects themselves. With respect to sensitive data, the Act provides that such data may only be transferred outside the country where the data subject has given the express consent, effective and appropriate safeguards have been put in place, and in line with any requirements or conditions set out by the Data Commissioner. The Act provides that the Data Commissioner has the authority to request evidence of security measures or compelling legitimate interests from parties transferring data outside Kenya. Additionally, the Data Commissioner may prohibit, suspend, or even impose conditions on the purported data transfers as it deems necessary to safeguard the rights and freedoms of the data subjects. Though there is no specific definition of the term appropriate safeguards provided under the Act, Regulation 42 of the General Regulations provide for what meets such standards with respect to a country or territory, including one that has ratified the Malabo Convention that's just been discussed above, that has a reciprocal data protection agreement with Kenya, or where there exists a contractually binding corporate rule among a concerned group of undertakings or enterprises, which specify 1. The structure and contact details of the group of undertakings or entities engaged in a joint economic activity and each of its members. 2. The data transfers or set of transfers, including categories of personal data, the type of processing and its purposes, the type of data subjects affected, and the identification of another country or countries in question. 3. The legally binding nature, both internally and externally. 4. The application of general data protection principles. 5. The rights of data subjects in regard to processing and the means to exercise those rights. 6. The complaint procedures. And finally, the mechanisms for ensuring verification of compliance with the binding corporate rules.
Thank you for that outline, Maurice. So it seems like putting in place appropriate safeguards is key when it comes to data transfers. John, could you describe this concept a bit further for our listeners?
Sure thing. So in further interpreting the term appropriate safeguards, which as Maurice pointed out is not even defined in the Kenya Data Protection Act, reference may be drawn from the European Union's General Data Protection Regulation, which is known in short as the EU GDPR, and which is actually the principal law on data protection, and which the Kenyan Data Protection Act actually borrows heavily from. Now, Article 46 of the EU GDPR is entitled Transfers Subject to Appropriate Safeguards. This provision allows transfer of personal data to a third country or an international organization only if the controller or processor has provided appropriate safeguards and on condition that enforceable data protection rights and effective legal remedies for data subjects are available. Now, in view of the similarities between the requirements under the Kenyan Data Protection Act and the EU GDPR, it is probable, although not altogether certain, that Kenyan courts and indeed the Data Commissioner will be persuaded by finding of courts within the EU as to the adequacy and appropriateness of data protection safeguards based on the yardsticks from these requirements as set out under the EU GDPR. So in effect, the EU GDPR is much more advanced in terms of developing this concept than the Kenyan Act is, and we may borrow appropriately from there. Article 46 of the EU GDPR provides an outline of the manner in which the appropriate safeguards may be provided for without necessarily requiring specific authorization from a supervising authority. These are listed as follows. So, number 1, there has to be a legally binding and enforceable instrument between public authorities or bodies. There's also need for there to be binding corporate rules as prescribed under the EU GDPR. There's also the need for there to be standard protection clauses adopted by the Commission in accordance with the examination procedure prescribed under the EU GDPR. There's also the standard protection clauses adopted by a supervisory authority and approved by the Commission, pursuant to the examination procedure also prescribed under the EU GDPR. There's also a code of conduct approved under the EU GDPR, together with binding and enforceable commitments of the controller or processor in the country to which personal data is transferred to apply appropriate safeguards. There is also a certification mechanism approved by the EU GDPR, together with binding and enforceable commitments of the controller or processor in the third country to apply appropriate safeguards, including as regards to rights of the data subjects. Now, Article 46 of the EU GDPR further provides that subject to authorization from the competent supervisory authority, the appropriate safeguards may also be provided for by contractual clauses between the controller or processor and the controller, processor, or recipient of the personal data in the third country or international organization, or even provisions to be inserted into administrative arrangements between public authorities or bodies which include enforceable and effective data subject rights.
That's very insightful, John. Thank you for that. Having discussed this legal framework that relates to appropriate safeguards, what would then be some practical steps that an organization, a government, or even an individual would then undertake while participating in these cross-border data transfers?
Well, some protective measures that one may consider when undertaking a cross-border data transfer include both pre-transfer measures when the data transfer is en route, and transfer safeguards upon arrival. To begin with the pre-transfer measures, protecting your data prior to transfer is essential to mitigate the risk of unauthorized access, disclosure, or even misuse during transit. Failure to implement adequate safeguards may bear consequences, including data breaches, financial penalties, reputational damage, and even loss of customer trust. Proactive measures help organizations demonstrate accountability and commitment to protecting individuals' privacy rights, enhancing trust and confidence among stakeholders. Some of these measures include 1. Pseudonymization of data. Pseudonymization involves replacing personally identified information with pseudonyms or codes, rendering the data unlinkable to individual identities without additional information. It reduces the risks associated with data transfers by minimizing the exposure of the sensitive information and enables organizations to comply with data protection regulations and requirements by implementing privacy-enhancing measures while still allowing for data analysis and processing of legitimate purposes. Secondly, the consent of data subjects is also required. The Act provides for principles of data protection and mandates every data controller or data processor to ensure that personal data is not transferred outside Kenya unless there's proof of adequate data protection safeguards, or consent from the data subjects. Thirdly, I want you to also consider limiting access to data that will be transferred. Securing access controls is essential for maintaining confidentiality, integrity, and the availability of data. It ensures that only authorized personnel can access and manipulate sensitive information, thereby reducing the likelihood of data breach or misuse. One may also consider having in place a data transfer audit checklist. These are the steps that must be taken to minimize the consequences of a data breach during the transfer that could cause great harm to the data subject. Moreover, these are the steps taken to maintain the sanctity of the data and the rights of the data subjects following the data transfer. Another thing to consider while undertaking a data transfer is the minimization of the data itself. The principle of data minimization requires that only the minimum amount of personal data that is required to meet the intended purpose should be collected and processed. It encourages organizations to gather only the information required to fulfill the stated purpose. Now looking at data transferred safeguards while en route. Protecting data as it moves across networks or during transfers is crucial to maintain its confidentiality, integrity, and availability. Here's how each of the mentioned safeguards can help in achieving this. 1. Encrypting data. Encryption transforms plain text data into ciphertext using algorithms, making it unreadable without the decryption key. During data transfers, encryption ensures that even if intercepted, the data remains protected. End-to-end encryption ensures that data remains encrypted from the point of origin to the destination, thereby providing an extra layer of security. One may also consider having firewalls in place. Firewalls act as a barrier between a trusted internal network and untrusted external networks, controlling incoming and outgoing network traffic based on predetermined security levels. Another measure to consider would be having access controls in place. Role-based access controls assigns permissions to users based on their roles within the organization, ensuring that only authorized individuals can access sensitive data. multi-factor authentication also adds an extra layer of security by requiring users to provide multiple forms of verification before gaining access to data. Lastly, one may also consider virtual private networks. Utilizing virtual private networks to establish secure, encrypted connections over public networks, thereby safeguarding data as it travels between endpoints. Lastly, let's look at the data transfer safeguards on arrival of the data. First, it's important to consider the assessment of the data protection infrastructure. Knowledge of the compatibility of the data protection infrastructure from where the data is collected to where it is received for use is key. Assessing the data protection infrastructure at both ends of the transfer is essential to ensure compatibility and compliance with applicable data protection regulations. Secondly, one should also undertake audit and assessment of the data protection infrastructure. This includes conducting regular audits and assessments of the data protection infrastructure to identify any vulnerability or gaps in security measures and addressing them promptly to maintain the integrity and confidentiality of the transferred data.
Thank you for that, Maurice. Those are very interesting, useful, and practical insights that I'm sure our listeners are taking note of. Now, I'd like to throw this question particularly to John. Given the appropriate safeguards that we've talked about, the legal framework that we've looked at, what would then be the responsibilities of the data controllers and the data subjects in all of this?
Thanks for that, Melanie. Maybe first we need to remind ourselves what a data controller and a data subject actually are. So a data controller means a natural or legal person, public authority, agency, or other body, which either alone or jointly with others determines the purpose and the means for processing of personal data. So this is a person who decides. It's the person who actually is the decider in the process. Whereas a data subject means an identifiable natural person who is the subject of the personal data. So with that definition in mind, let's look at the two. Data controllers and data subjects have crucial roles to play when it comes to data transfers, which together ensure the safety and security of data upon such transfers. First, let's look at data controllers. I would say that these are the people who are responsible for ensuring that data transfers comply with applicable data protection regulations and that adequate safeguards are in place to protect the transferred data. Data controllers should also conduct due diligence on data recipients and enter into contractual agreements or standard contractual clauses to ensure that data protection standards are maintained throughout the transfer process. Data controllers must also seek a legal recourse against data recipients or third parties involved in the unauthorized data transfers or breaches of contractual obligations regarding data protection. Collaborating with data protection authorities and regulatory bodies to investigate and address any breaches or violations related to data transfers, and they should also ensure compliance and accountability throughout the process. For data subjects, they have the right to be informed about the transfer of their data so as to ensure full transparency and accountability in the process. Data subjects may exercise their rights under data protection laws, such as the right to access, rectify, or delete personal data, regardless of where it is transferred. Data subjects can also lodge complaints with relevant data protection authorities if they believe that their data protection rights have been infringed upon during or after the transfer process.
So thank you for joining us in this conversation today, John and Maurice. Any parting shots?
Yeah, so I think as a parting shot, I'd say that the key is to ensure that throughout the transfer of data, either pre, during, or post-transfer, all data protection principles are borne in mind so as to not fall afoul of the data protection laws that are in place. So our word of caution out there is just to be aware of what these requirements are as we've set out in the preceding take, and have a look at the EU GDPR if you ever get lost, because the EU GDPR actually is much more advanced and has much more detail, as the Kenyan Data Protection Act is a latter act compared to the GDPR.
Very well said by John. And also, let's not forget the continental framework we have, the Malabo Convention and the Supplementary Act on Data Protection within ECOWAS, which also provide a framework in which we can rely on when looking for guidance in cross-border data transfers in Africa.
To our listeners, thank you for tuning in. Stay tuned for our next episodes, where we'll continue with this conversation where we discuss essential topics in data privacy. We value your feedback, and thus we encourage you to reach out to us on our social media channels using the hashtag #OSIO Roundtable. Until then, goodbye and take care.